morning and good evening, one and all present here in this webinar. I thank you all for sparing your valuable time and being a part of this webinar organized by markpattern.org and sponsored by HK and Company. This is your host Jalashri Dave for this webinar and a part of markpattern.org. I warmly welcome all of you. Namaste. We hope you are staying positive and testing negative. With this webinar, we are accessible to a global audience that brings together a wide and varied group of people connecting in this digital world. So before I start, let me give a quick introduction about our organizers and co-organizers. Our organizer, markpattern.org. Markpattern.org, established in 2004, is actively associated and dedicated to the support and advancement of intellectual property elements. The main object of the organization is to provide in-depth understanding and to create awareness of intellectual property right among attorneys, advocates, professors, law students, and also among manufacturers, industrialists, traders, and general public. Markpattern.org undertakes various activities at local, national, and international levels by organizing trade fairs, exhibitions, seminars, lectures, and study circle activities to propagate the knowledge of intellectual property laws to the layman and thus creating awareness, developing recognition, and acceptance of the intellectual property rights. Our co-organizer, USIIC, US India Importers Council. It's a non-profit initiative started by the group of Indian SME importers responsible for imports of over $1 million from the USA. USIIC acts as an intermediary organization to facilitate partnership and trade between India and American business, and thus acting as a catalyst in promoting economic growth between the United States and India. GLS Law School. GLS Law School, a new venture of Gujarat Law Society, launched in the academic year 2015 and 16, has emerged as the most preferred destination for legal education. GLS Law School is affiliated to Gujarat University and offers BA LLB degree, which is recognized and approved by the Bar Council of India. Senior practicing advocates also contribute in teaching and providing experimental learning to the law aspirants. School of Law, Gujarat University. The University School of Law in Gujarat University was established in 1977 and is one of the highest ranked law colleges not only in Gujarat but also occupies a top spot ranking in the national level. It offers a 2-year full LLM course in the intellectual property rights. Xavier's Research Foundation. Xavier's Research Foundation Trust runs the Loyola Center for Research and Development, an autonomous institute. It was established in the year 1987 in St. Xavier's College, Ahmedabad. Its goal is to do research in science and technology and humanities. The center not only employs scientific staff dedicated to research, but also provides infrastructural support and expertise to students working on the frontline fields in environmental microbiology and plant biotechnology. The mission of the center is to target grassroots communities on the fringes of our economy and through innovation, entrepreneurship training, and handholding, setting up production units at medium, small, and micro levels. Institute of Law, Nirma University. Founded on the vision of Padma Shri Dr. Karsan Bhai K. Patel, the Institute of Law, Nirma University, embodying the principle of justice, education, excellence, and professionalism, imparts quality legal education and has produced new generation lawyers, leaders, and policymakers over the years. Gujarat Technological University. It's a premier academic institute and research institution which has driven new ways of thinking since its 2007 folding, established by Government of Gujarat. GTU is a state university with 486 affiliated colleges in fold operating across the state of Gujarat through its 5 zones at Ahmedabad, Gandhinagar, Vallabh Vidyanagar, Rajkot, and Surat. The university caters to the field of engineering, architecture, Rajkot, and Surat. The university caters to the fielding of university and having 4 lakh students enroll in a large number of diploma, undergraduate, postgraduate programs, along with the robust doctoral program. LD College of Engineering. Lal Bhai Dalpat Bhai College of Engineering, Ahmedabad is a premier government engineering institute in Gujarat, set with the objectives of imparting higher education, research, and training to the college Technological University in Ahmedabad and administered by the Department of Technical Education, Government of Gujarat. LD College of Engineering was established on 20th June 1948 as one of the first few engineering colleges in India. The institute owns its foundation to be the bold and inspired vision of Kasturbai Lalbai, who named after his father, Lalbai Dalpat Bey. Initially affiliated to the Bombay University, LD College of Engineering came under the Gujarat University after it is established in 1949. So we once again thank you, our organizer and co-organizers. So now moving forward, may I please welcome our dignitaries. Managing Trustee at markpatent.org and proprietor of HK Acharya and Company, Dr. Rajesh Kumar Acharya. Patent Attorney and Managing Partner of Kwan and Kim Patent and Trademark Attorney, Mr. Yung Jun Kwan. US Patent Attorney and Partner of Harvest IP Law LLP, Dr. David Ho. Partner of Aoki, Ferreira, Mattioli and Yamashita Intellectual Property Firm, Ms. Katya Jain Ferreira. USPTO Registered Patent Attorney and Founder and President at Golab Intellectual Property, Dr. Mario Sergio Golab. And Senior Advisor, Projects and IPR Domain Expert, Mr. Padmin Bhuj. I heartily welcome all of you. So, ladies and gentlemen, it's my pleasure to introduce Dr. Rajesh Kumar Acharya, Managing Trustee at markpatent.org and proprietor of HK Acharya and Company. He is a patent and trademark attorney and is registered to practice law before Indian and Canadian patent and trademark offices. He is also a member of the Bar Council of Gujarat, having an extensive background in the prosecution and litigation of all IP-related matters. He is best known for his books on IPR laws in India that includes the patent law, the trademark law, the copyright law, the biological diversity law, and the design law. He has accumulated a wealth of experience in prosecution and litigation of patent, trademark, design, copyrights, and other intellectual property-related matters. He is also a member of various national and international organizations related to intellectual property laws. He is member of Indo-American Chamber of Commerce and the president of United States India Importer Council. So with my utmost pleasure, I invite Dr. Rajesh Kumar Acharya before you to share his piece of wisdom.
Thank you, Jalashree. Good evening, good morning, good late evening, and good time rather. I welcome all of you on my personal behalf as well as on behalf of markpatent.org. And since 2004, markpatent.org is organizing seminars every year, and it is just to impart and share the knowledge regarding IPR. The topic today, it is intellectual property rights in artificial intelligence, latest challenges. I'll put it in other words, it is artificial intelligent property rights. Today, it is the topic rather. I'll say that, well, we are organizing seminar every year, and I was attending so many global seminars in different countries. Since last 2 years, I couldn't travel at all because of this pandemic, and it was rather very difficult. This artificial intelligence helped us to arrange this webinar. We are thankful to artificial intelligence. I'll say that as such, artificial intelligence is since very, very long time with us. But we are not knowing the challenges of it. Since the car or since the invention of the aeroplane and everything, it is artificial intelligence. Now the question is, everywhere the question arises that in artificial intelligence, who is the owner, who is the proprietor of artificial intelligence? It is being challenged in many, many courts, as well as when there is something mishappened, then who is liable? I'll tell you that now there is a driverless car. And when this car makes any accident, then will be the liable for that, whether the car or the owner of the car. Because when it is with the driver, then always driver is the liable for any accident. So these are the challenges coming up, and it is growing very fast everywhere. So because even in the IP offices nowadays, IP offices are being run by artificial intelligence. They are do the prior art search. They do examine to some extent, and maybe in future they will issue the patent certificate by its own. And where will be our requirement as a patent attorney? They can draft the patent application also from the prior art search. These are all the challenges we'll be having. Today we have a galaxy of wonderful speakers on this artificial intelligence media webinar. As we have Mr. David Coe from World Capital, Washington, D.C. We have Mr. Youngdon Kwon from South Korea. We have Dr. Mario Galab from Miami, USA, from Florida. We have one Miss Katia from beautiful countries, Brazil, Sao Paulo. Also, we have Mr. Chirag Patel will be joining very soon with us. It is a galaxy of the speaker, and certainly will enjoy these latest challenges which is coming up. Thank you very much, and welcome all of you. Over to Jalakshmi.
Thank you so much, sir. It is under the guidance of Dr. Rajesh Kumar Acharya that HK Acharya & Company is now a team of highly qualified and expert visionaries, as well as markpatent.org is a very fortunate to have such a thoughtful and dedicated member who is constantly guiding and supporting the organization. So this webinar will have series of sessions which gives flavor to the remarkable diversity of the subject matter of IP and its connection with artificial intelligence. So now, may I introduce to you all our first speaker of this session, Mr. Youngjun Kwon. Mr. Kwon has completed his Masters of Law from Northwestern University School of Law, USA, and Master of Science in Chemical Engineering and Life Science from Yonsei University. He is an advisor of the Central Pharmaceutical Affairs Council of Korean Food and Drug Administration, and also an advisor of Korean Government Trade Commission. He is a patent attorney assisting SMEs in their IPR protection at the Ministry of SMEs and Startups of Korean government. He is also a Korean technology transfer agent at Central Pharmaceutical Affairs Council, Korea. Mr. Kwon is a member of INTA, PTMG, ECTA, APA, and KPAA, being the Attorneys Association. So now I request him to present his thoughts with us.
Yeah, my name is Youngjun Kwon from Korean Game Patent Trademark Attorneys in Seoul, South Korea. And I'm grateful for invitation to speak here today about a few of artificial intelligence topics. And I'll be focusing to deliver general knowledge related to recent developments or that have been discussed in Korea for AI technology in view of intellectual property right, rather than dealing with details dedicated to one single topic. And then which will be matching with today's title of a conference, IPR in Artificial Intelligence Related Challenges. There are three topics, and I'll start with Artificial Intelligence Patent Examination Guideline in Korea. And let's see. Okay, before this, it is a diagram for the clarivate showing which countries file more patent application for AI technology and which countries file how many strong patent application for AI technology. Here, the strong patent means that how it is cited more against two other application, and also how many parallel foreign applications were filed based on instant domestic application. So as you see in the graph diagram, the Korea has the 4th rank and India 10th rank in number of the application. But for the citation pattern index in the right diagram, the Korea is just maybe 6, or the Korea and compared with the India and Korea, and India is overranks on Korea in quality of patterns. More dramatic changes are happening in China. China is the top of the top in the numbers, number 1 in the filing numbers, but for citing ration, China is just to next the end in the list, which means that the Chinese pattern for the AI technology has very low citation or less pattern families filed overseas. Maybe probably most of China's AI technology application are filed only in China only. It is a big difference between USA, Canada, and China and France. Next, I come back to the Korean examination guideline. Last January, the Korean Intellectual Property Office, KIPO, announced pattern examination guideline for AI technology invention, which is based on machine learning. The basic overview diagram in the screen is AI-ready invention used in the examination guideline. The guideline divides the machine learning AI technology invention into 2 main categories. The first category is the upper part, AI model training invention, which is also subsequently categorized to data preprocessing technology and to building technology of machine learning model. So data preprocessing is meaning like doing data editing or data cleaning, data labeling, or reducing for better quality of AI technology analysis or more appropriate, more efficient AI technology processing. And also the second category of invention is AI application invention, which is a kind of sort of appliance invention of AI technology. So this is categorized the Korean Patent Office divided for the examination guideline. Next slides are the about requirements stipulated in the guideline for the patent examination to be patentable. The first one is enablement requirement. As in other jurisdiction and also in other technology category, for AI invention, the specification should explain clearly and fully for invention so that a person who is ordinarily skilled in the art to which the invention pertains can easily practice the claimed invention without substantial difficulty. In this regard, for the AI invention, Kiefer suggests that some key elements should be clearly explained in the specification, which are training data, data preprocessing, training model, and loss function. The loss function means it is all called also error function. It is kind of the average loss of the entire training data set, and they should be explained in the specification in order to enable the skilled person to practice the claimed invention. More specifically, the AI application invention, we should provide details on the correlations between input data and output data of training model. The correlation between data is very important in Korean examination guideline, as I explained later. We should specify the training data, and we also should describe the correlations among the characteristics of the training data for solving a technical problem. And also we should indicate the machine learning model to be trained using the training data or training method. And also we should describe what or how it be the generation of training model that solves the technical problem by using training data and training method. And for the AI training data invention, we similarly should describe the steps and function of data preprocessing, which is how raw data is processed to generate and change, add or delete training data. And also we should include the correlations between raw data and training data. For example, we should explain the raw data used, how raw data used, and why the training data processed in a certain way. And next, for the reinforcement learning invention, we should specify a method of reinforcement learning, including the correlations among agent, environment, state, action, and reward, enough for the person to work on repeat invention without difficulty. So as you know, as you hear from me, our requirement is about relations from data, input data, output data in the model, in the method, and training model and training method in the Korean examination guideline. Next is about inventive step for AI invention. AI invention that simply use AI technology in systematizing or computerizing process that could be or had previously been manually conducted is unlikely patternable. For example, if we simply modifying the design of conventional AI technology or simply changing a training model, known the disclosed already training model, or merely adding, substituting known technology to the conventional AI technology, they are all denied inventive step in Korea. So for the invention to be patentable, we should add distinguishable technical features for solving technical problem, such as training data or data preprocessing, training model, loss function, or we should specify the differentiating technical configuration by using a technology, or the invention should be related to elaborating on the technical effect directly from the technical configuration that go beyond the effect conventional AI technology. Otherwise, like the faster processing speed or the better efficiency in processing data or reducing errors or more accuracy, such thing might not be sufficient to be patentable in Korea, as the guideline said. And also I explained specifically for AI training invention, we should provide specific details about how raw data is processed for training data. For example, we should describe how features are extracted, processed, produced from input data, how the training data is generated by standardization or normalization or vectorization. Of course, the general or simple ways of standardization, normalization, vectorization will not be possible to get a pattern in Korea simply by standardization or normalization, vectorization. And also we should explain the particular effect or improvements that can be derived from the data processing. For example, we take a CCTV process as an example. If the invention comprised performing data preprocessing on video images of CCTV for taking motion tracking features to identify the image itself. Therefore, the identification capacity for the CCTV improved. That could be particular effect to be patentable. However, if in the invention simply use the video images to identify objects via technology, that could not be particular effect to be patentable in Korea. That could not be differentiating features to be patentable. And next, the AI modeling invention. For AI modeling invention, we should describe specific configuration modeling, such as the configuration training environment, model evaluation, linking multiple model like connecting many nodes in their neural networking, parallel or disturbed processing, and optimization hyperparameters. And also we should provide effect regarding training speed, prediction accuracy, training model that are caused by specific configuration and thus not effective from the conventional AI technologies. And next, for AI application invention, similarly with the other inventions, we also should describe the specific use of the output data of training model and the effect of using output data in a particular manner by using output data of training model. And next topic, the AI technology is mainly or widely used or applied into computer-related or the computer-implemented invention or software inventions. However, the AI technology is also extensively used in the pharmaceutical field too, as you may know or not. Among others, AI technology is very useful in finding out the candidate material for new drug to cure human diseases. We call it drug repurposing or repositioning. The drug reproposing, which was known as drug repositioning, involves the investigation of the existing drugs for new therapeutic purposes. For example, the most famous and most successful reproposing of existing drug is Viagra for the sildenafil compound for the curing the human erectile dysfunction. Such a drug reproposing has become very promising approach because of the opportunity reducing substantially developed timeline and cost and the efforts of a human being or the pharmaceutical companies. Generally, timeline for new drug development is known as 10 to 17 years. Of course, we have some exceptions like the COVID-19 vaccine is very short time taken for developing, but generally 10 to 17 years. But for drug repositioning, it could be just 3 years, only the minimum one. It's very time efficient for developing new drugs. So in such big data modern era we live on, the artificial intelligence technology offers a cutting-edge application of information science to finding disease, medicine, therapeutics, and identifying targets with release data. So there is a concept of targeting while in drug reproposing as to finding out what causes specific disease against which drug should work. The target could be protein or gene causing specific disease. And once such target is decided for developing new drug, there are a process called screening or high throughput screening, which is a compound screening process that are conducted against tens of thousands and sometimes to millions of candidate material to find the target to hit. So it is very much time and effort consuming. So the screening process is very time and cost consuming. Thus, AI technology such as FDNN, or convolutional networking, neural network, or regression analysis can have this process out via data-driven virtual screening to save time, effort very much substantially. Through this process, the scientists can rapidly identify active compound, antibodies, or genes that modulate a particular biomolecular pathway. The result of this experiment provide starting point for drug design and for understanding the low or particular location of the gene or the protein. So in this way, under this circumstance, in view of pattern protection, in silico analyzing method using virtual screening by AI technology can be patternable as a computer improvement method of invention. And however, in silico analyzing method via non-computer program or non-algorithm operated following known ways will lack novelty or inventive step, of course. However, for candidate material found with such in silico analyzing method with virtual screening, the screening method will be patternable in itself. And also, material found by from in silico analyzing using AI technology will be also patternable, although the material is not new if pharmacological effect is proved through the chemical experiments. That means novelty of material does not matter here because it is about medical use invention, which is not protected in India though. So the material compound or pharmaceutical composition found by in silico analyzing technology, this in silico analyzing method via virtual screening using AI will be a combined invention with AI technology and pharma technology, so that both examination standard for AI technology and also chemistry or pharmacy technologies. So the material found with such in silico analyzing method is very interesting invention, combined two far-end technologies of software and pharmacy or chemistry. That could be patternable in Korea now. Next, last topic is very well known, and I think it's a very short one. In Korea, as in other countries in the world, actually, I think all countries in the world, in pattern world, the inventor should be a natural person. However, a gentleman named Stephen Taylor, who is AI technology scientist, filed an application in Korea with naming his machine called Davos as a sole inventor on his application. He is also known to file the application in the same way in other countries, including US, EPO, and UK. And so, who will be the inventor between AI developer Mr. Taylor or his AI machine Davos? Actually, there's no inventorship for AI developer Mr. Taylor. So Mr. Taylor is not eligible to be inventor technically, and also he wants to be named in the application. But AI machine Davos is a natural person, so we cannot name the Davos in the application for inventor. As a result, if there's no inventor, Mr. Taylor will name for application. So the application was not accepted to proceed in Korea, like US, UK, or EPO. Even Mr. Stephen filed appeal to the higher appeal board, but all appeal was rejected because AI is not natural person and cannot be included in the name as an inventor in Korea. And also, lastly, there is issue and discussion that AI machine can invent much more easily new invention than natural human being. Thus, the 20 years of protection should be too long to the AI invented invention, thinking the AI small efforts spent its invention. So someone think the patent term should be reduced for AI invented invention, but I'm not sure such a discussion can be happening in other countries like India or Europe or Brazil or somewhere. But I want to ask you all, how do you think if we should shorten the 20th patent term for AI invention or not? It's all. Thank you for listening. Thank you.
Thank you very much, sir, for discussing the topic in very comprehensive way. So now I would like to invite our next speaker of the session, Dr. David Ho from USA. He received his Bachelor of Arts in Chemistry and Biology at Indiana University, his Doctor of Philosophy in Medicinal Chemistry at Purdue University, and his Doctor of Jurisprudence at American University. He is admitted to the state of Maryland as an attorney and is registered as patent attorney before U.S. Patent and Trademark Offices. As a partner of Harvest IP Law LLP in Washington District of Columbia, Dr. Ho handles different stages of the patent application process and focuses on technologies related to the chemistry, biotechnology, material science, and consumer products. Dr. Ho was born and raised in Hong Kong. Prior to his legal career, Dr. Ho was a scientific researcher at the Ohio State University and the National Cancer Institute. He is a co-inventor of methods of treating breast cancer cells. So now I request him to share his thoughts with us. Over to you, sir. Sir, kindly unmute. Sir, kindly unmute your audio.
Yes.
Yeah.
Yes. Can you see my slides?
Yes, sir.
Good. Okay. My name is David Ho. My topic will be current issues and future perspectives of inventions based on artificial intelligence. I want to show my appreciation to Dr. Acharya for inviting me to be part of this conference. Thank you very much. Today, I'm going to focus on three aspects in my presentation. The first one is, what is artificial intelligence? The second one is, what are the current issues regarding artificial intelligence? The third one is, what are the future perspectives? Artificial intelligence can be implemented in many technical ways. Today, I want to focus on 8 of them to share with you how artificial intelligence is involved with different type of technology. The first type of technology is called the knowledge processing. The AI in knowledge processing gathers and derives facts and uses this information in an automated way. So one illustration is the patent issue to Intuit. It's a United States financial company that puts out lots of software for tax filing and other aspects. So this particular invention uses a predefined knowledge base to automatically detect accounting error. So the filer of tax information and can be assisted without much error, will be very efficient. So this is one first example of artificial intelligence in the area called knowledge processing. The second one is speech. The AI in speech uses technology that understands the sequence of spoken words, the spoken words. So the first example is the patent issued to Apple computers. So this invention is like an automated assistant that answers to spoken questions or instructions. And of course, this is what related to the Siri and Apple and other assistants in the other platforms. So this phone, and there are times that this assistant is so helpful that although I'm not giving an instruction, it'll be interpreting something, say it again or something. So we all have experienced such a technological impact of artificial intelligence. The third type is called AI hardware. AI hardware uses physical computer components to achieve a much better efficiency and speed. The example is the one patent issued to IBM. This invention is a very good and efficient computational system that provides electronic synapses that configured for the reinforcement of learning. The synapses, they're using presynaptic electronic neurons as well as postsynaptic electronic neurons. So now you realize that the computer system, the artificial intelligence, is borrowing the biological world, how an action potential is being transmitted in a nerve cell from a presynaptic end to the postsynaptic end. Therefore, this entire technology, this application is also called the artificial neural network. The fourth type is called the evolutionary computation. The AI in the evolutionary computation will use computational routines that utilizes some aspect of the natural and evolution world. One example is the one US patent issued to Chevron. Chevron is a US oil and gas company. Is looking for where they should go to find the next oil field for the use of from energy derived from the oil field. So this invention is to forecast the production profile of a petroleum reservoir for the company. Using this called genetic programming, it's trying to mimic and borrow the idea of evolution, putting some mutation. These are terms that are related to the biological world, the evolutionary world. That is why it is called the evolutionary computation. The next type is called natural language processing. Natural language processing. The AI in natural language processing gives a computer the ability to understand text and spoken words in a way that is similar to what a human can understand and interpret. One example is the patent issued to Cincinnati Children's Hospital Medical Center. So the AI in this invention simulates human recognition of text and then assigns billing codes to clinical records. So it knows the communication from the patient. In addition to this clinical work codes and billing codes, it also is able to understand suicidal notes. So in other words, when a patient is not in a good mood, maybe some inkling of, oh, I don't want to live anymore, or something negative, this AI would know that and assign and put a notation to this suicidal notes. So this is not just an efficient way to assign billing codes. It is also an invention that helps the doctor knowing the suicidal nature or inclination of the patient. Very useful invention, very practical. The next one is called machine learning. Machine learning is using the data, identify the patterns, and make a decision without human intervention. Example is the one issued to the invention, a patent issued to Walmart stores. Walmart store is a US big store that has a lot of selling products, reviews, many data. So this invention uses the algorithm to optimize e-commerce for the platform by classifying the products, by handling the reviews and other features. And also it applies a process called crowdsourcing to resolve ambiguous results. Crowdsourcing is the practice of using many people to derive at a certain decision versus outsourcing. Outsourcing is a very committed mission. An employer would say, I need you to handle this particular mission. So very specific. But crowdsourcing is just using the public out there to come with some answer. So this is a machine learning, one aspect of AI in technology. The next one is called vision. AI in vision. It knows how to interpret information from images, from videotapes. So one example is the patent issued to Mayo Foundation and Arizona State University. The invention is about how to optimize the images during a colonoscopy procedure. So the doctor with a scope going into the colon area, and then the invention will detect automatically any abnormality. As we know, the colon is a pretty long part of the body. There's a ascending, a crossing over, and a descending, and then eventually coming out of the body, so to say. So colonoscopy is the best way to prevent colon cancer. It's a preventable cancer. So this invention, this AI application of the invention will catch all abnormality. So the process is very smooth. The doctor can give a report quickly, and the patient is being helped a lot. Okay. The next one is called the planning and control type of AI. What is planning and control? It is using data that is identified, created, so that together it contributes to the planning and control. It is especially useful for a manufacturing plant. So this patent issued to Fisher-Roseman system, which is a processing and production company. So it uses, this invention uses a mobile device in the processing plant and say, hey, I see this phenomenon, what's going on? And then it reports to the expert system. And then if there's any potential problem, it could be prevented. So this is very helpful in, as you can imagine, manufacturing of electronics, automobiles, and pharmaceutical products and everything, so on and so forth. So AI is very helpful in the planning and control area. There are many other types. For the sake of time, I've just used our time to focus on 8 of them. My next topic is what are the current issues? So the first one, it will be, what are the elements in an AI invention? The problem to be solved, the computer functionality that is capable of learning, the structure of the database that is used for the invention, the algorithm that analyzes the database, the training and the learning part of the database back and forth to come up with more knowledge, and the result, of course, after all these things. So these are a cluster of elements that the community, the inventors community, the practitioner community all agree to. The next issue will be, can the contribution be made by a non-natural person. So the 35 USC 100 defines what is an invention. An invention is person who discovered the subject matter. So it's person. As we know, conception of the idea of the invention implies inventorship. That's the required condition, the conception of the idea. What about the reduction to practice? Normally, it's a technician and other scientists, engineers going to fulfill all the details. Here in AI, with the AI machine, doing everything faster than human. I appreciate Mr. Kwan's discussion already. What about those? Reduction to practice only cannot be an inventor. In other words, if I'm the inventor of an AI invention, I think of the algorithm, I think of the design of the AI machine, I can be an inventor. Of course, there are many times I'm also part of the research laboratory, so I'm part of the reduction to practice. That's fine. I am still an inventor. But however, if the data scientist only carry out the AI algorithm and obtain the results, not the conception of the idea, that person is not an inventor. So again, the AI machine is not a person and cannot, in the eyes of the US up to this point, is not the person who conceived the idea. So the AI machine cannot be an inventor. The next issue is number 3. Do we need to change any patent law at this point? Let's say there's an artificial general intelligence. It is a hypothetical agent capable of learning like human being. What if this AGI becomes a reality in the near future? What should we do? Up to now, the common consensus, no, there's no need to change the law to accommodate this situation, because again, conception is still inherently a human activity, a human contribution, so cannot be contributed by a machine. Machine is very smart, no doubt, very automated, very quick, much better than what we can do as a human. But because the machine cannot conceive the idea, so again, there's no need to change the law. I just have to share with you some further details used under the US law. 35 USC 100 is a definition of an invention. Inventor is the individual who invents, not the machine, all right? There's another aspect in the USC code, section 101, whoever invents. It didn't say whatever invents. So therefore, again, it is not an AI machine. The third aspect is 35 USC 115, which relates to the declaration of an inventor. An inventor would say, yes, I did this myself or herself. So to describe the person who is going to make the oath of being part of the invention is referred to himself or herself, not itself. So again, from these activities, we know that it's quite clearly defined. There's no need to change any law up to in the foreseeable future. Another issue, number 4, should the AI machine be the owner? And up to now, saying no, only a natural person or company by assignment should be considered the owner of a patent. So far, no one will accept that the AI machine is a company. So AI machine cannot be the owner. However, some people will say that what about the natural person who trains the AI process, the machine, who controls the AI system? What should this person be? Then people say this person who trained the machine should be given more consideration to be the owner of the invention. So it's a debate of about this person who trains the machine. He should be part of the company that owns the AI invention. So you can look at it this way. Therefore, again, In short, AI machine cannot be the owner, but the person who trains the AI machine should be the owner too. So it is a debate between the ownership, the management of the company. Number 5 is an AI claim eligible for subject matter. So we're now looking at the claim in an AI invention. First of all, is a claim one of the 4 statutory categories. Is it a process? Is it a machine? Is it a manufacturer? Or composition of matter? If it is, fine. Then we have to look at the claim. Is the claim directed to a judicial exception, meaning the law of nature, a natural phenomenon, maybe an abstract idea? If so, then we have to further evaluation, what we call the step 2, prong 2. Is there an element inside this claim that integrates the judicial exception into a practical application? If yes, it's fine. It's an eligible subject matter. Further, there's one more question, step 2B. Is there an element that amounts to significantly more than the judicial exception? So the subject matter is a hotly debated area. It gives the practitioner a lot of challenges. It's what we call the 35 U.S.C. 101 subject matter evaluation. I'm following this step 1, 2A, prong 1, 2A, prong 2, 2B as a summary of an analysis of the U.S. examiners. All right. Now, let's look at the third area of our focus. What are the future perspectives? I'm using artificial intelligence as a term, any part of the application, of the invention, of the patent. And then I just search for the country, as any country. So these are my results. In USA, 36,000 patents and 14,000 applications and that are out there that are searchable. The next country is Korea, 2,800 some US patents issued and almost 2,000 US applications in the process. Okay. In Japan, the next country would be Japan, 2,000, almost 2,500 issued patents and 1,700 US applications. The next country is China. It's almost 1,000 US patents and almost 1,000 US applications. Then I just want to summarize the rest of the country: Germany, Canada, United Kingdom, Israel, Taiwan, and India. So this is the overall landscape with respect to the AI inventions in the US system. So, all right. The next trend is to see the top companies in the AI inventions. This is a mix of the WIPO report as well as my extra searches using the US system. IBM is known to be the leader among all the companies in the world. Worldwide, meaning anywhere, in addition to US, UK, Europe, China, Korea, India, all over the world, 8,200 plus applications. At the same time, with respect to the US arena, there are almost 4,000 US patents issued and almost 1,000 US applications going on. The next country, Microsoft. I'm not going to just draw your attention. Microsoft, the next one, Toshiba and Samsung. This and NEC of Japan, the fifth one. The other companies will be Fujitsu, Hitachi, Panasonic, Canon, and Google. And notice that in Google, which is a US company, has a lot of US patents. With respect to worldwide application, not as many, only 1/2 of IBM's. But there's a lot of US patents issued and a lot of US applications. So this is the overall sense. I would like us to get hold of that from the perspective of the top companies in AI inventions. The next area would be, that caught my eye, would be the Asian institutes in AI inventions. The top institute is the Chinese Academy of Sciences of China. It's a lot of worldwide applications. The next one is Korea ETRI, Electronics and Telecom Research Institute. The next one is a Chinese university, Xidian University. It's in Xi'an, the electronic, focusing on electronic technology. So this is the university. The next one, Zhejiang University of China, and IACF, Industry Academy Cooperation Foundation. The last one I listed is KAIST, Korea Advanced Institute of Science and Technology. I want us to just to understand and appreciate that a lot of inventions are being filed worldwide under these Asian institutes. Although at this point, the US patents or US applications are not many, not at this point. But I would like us to focus on them and keep track of them. Keep an eye on the activity from the Asian countries through their research institute and universities. In terms of the academic production, high, marvelous. So of course we know that academic paper, a journal article, is not a patent. We know that. But if these folks are working so hard in advancing the technology, one day in the future, they will be contributing in the AI in patent application worldwide. So keep an eye on this and the whole area. It's a worldwide phenomenon. We're all connected somehow, somewhere. So what about your US universities? University of California, MIT, Johns Hopkins, University, Texas, Stanford, Harvard are the very outstanding universities. These are the listing of the WIPO data, worldwide data, and US patent and US application. As you can see, these are US research university, top-notch university. We noticed that they're focused on the US patents and US applications. And in contrast to the Asian Institute, their other application in other jurisdictions are much less. So that is the trend we can see. That, in other words, the US university focus USA, the Asian Institute focus primarily in the Asian jurisdiction, much less the USA. We believe that one day US is a very important country for filing of US for the application. One day the Asian Research Institute will come over to the US. And one more trend for the future, so we can see, appreciate that AI will impact in many ways in our world. Transportation, and Dr. Chari already mentioned, what would happen if there's an accident? It's a very good question, very fair question. What should we do if there's an accident? Who is to be blamed? Who is liable? Very practical topic. I believe somehow the driver, if he or she sits in the car, bears some responsibility. The designer, the manufacturing, many ways. So we know that AI has already impacted our telecommunication in many different ways. It's already impacted our healthcare, in medicine, business and finance, everything. We're being predictive what to do. All right. So these are very, very exciting because we're only seeing the initial wave of this excitement. However, I want to let you know, I strongly believe in AI, but AI cannot replace the human beings, at least in these following activities. Cannot carry out exercise. No. AI cannot substitute me from swimming. I have to swim, I have to walk, I have to get healthy, I have to lift weight. AI cannot make decisions for me or express an emotion for me. Of course, AI is going to prompt us, right? One aspect is when we drive, somehow the GPS is going to direct us a certain way due to the traffic condition and everything. I can choose a different way. I'm still in control. Okay. And one more thing, AI cannot substitute us, human being, in creating inventions, the creativity. No one can substitute that. And also choosing friendship, choosing direction. So those are the things I want us to keep in mind. Last but not least, these are the references that I've used to compile for this presentation. And I want to thank you for your attention. Thank you very much.
Thank you very much, Dr. Ho, for delivering this informative speech. So now let me introduce you our next speaker of the session, Ms. Katya Jain Farharia. Ms. Katya Jain Farharia is the founding partner of Aoki, Farhera, Mattioli, and Yamashita. She is experienced in technological innovation with focus on the protection and defense of intangible assets in the advisory, strategic, administrative, and judicial areas for 25 years. Ms. Katya graduated in chemical engineering in law, did her postgraduate in cosmetic chemistry and competitive intelligence. She is an expert in patent searches and currently a master's student in law. She is also an invited professor for undergraduate and postgraduate courses, as well as in-house training courses for national and multinational companies, startups, and research institutions. She is a member of Brazilian Association of Intellectual Property, Brazilian Association of Industrial Property Agents, and many international IP associations. She worked in strategic planning, drafting patents, as well as administrative and judicial defense of hundreds of projects. So now, I request her to share her thoughts with us. Over to you, ma'am.
Thank you very much for your time. Thank you for the invite. We are in Brazil, a sunny day, a colorful country, and it's a pleasure to talk to you and share some thoughts about this important subject. I try to share my screen. Is it okay for you?
Yes, ma'am. Yes.
So the subject here is latest developments in IP protection in Brazil. And we try to talk a little bit about our landscape of IP regime in Brazil and South America, and latest developments in IP protection in artificial intelligence, and talk a little bit about artificial intelligence in Brazil. This is a new subject for us in our country. First topic, landscape in IP regime in Brazil. Our region, South America, is composed of 12 countries. Our main language is Spanish, but Brazil talks Portuguese, a very different language in our area. Our GPG is more than 1 trillion. And we have here 2 important trade blockings, Mercosul, which Brazil takes part in, the community. The IP regime particulars, we don't have any IP agreement, and there is no centralized patent office. All countries are members of Paris Convention, and our IP legislation is harmonized with the Indian community, but Brazil don't take parts. And the majority of countries like Brazil take parts of PCT. Our law is a very little complicated. Unfortunately, we had a specific law until 1996 with limited patent possibilities for a lot of chemical fields and food fields, and we had a transitional period, and the current law accepted protection for all fields. Our main, how can I say, patentability requirements are novelty, inventive step, and applications, and also like all the other countries. And the main problematic in Brazil now is the patent term. I will talk to you and show to you how this impacts in AI area. And in Brazil, the IP protection is recognized for industrial property, copyrights, and some sui generis protection. And in AI area, we can think about patents, software protection, integrate circuits. Our level of IP litigation in Brazil is very high compared to other countries. This is an evaluation recently done by our firm. Brazil, Argentina, and Paraguay are the most competitive countries in number of court actions. Our court actions in Brazil are about infringement, nullity actions, and we have in Brazil 2 specialized courts in IP, in São Paulo and Rio de Janeiro, the main cities of our country. The latest development in IP protection in Brazil. I need to talk to you about the backlog in patent examinations. Brazil was facing a backlog in patent applications. We had 200,000 patent applications for examination in the recent years, and about 14 years to grant or reject a patent in the IT area. So this was due to a reduced number of examiners and all the situation of BPTO facing in the recent years, less investments and a lot of situations. The problem is that our law, unfortunately, consider that no patent shall be valid for less than 10 years. So the patent terms in Brazil in all areas are more than 20 years, different from other countries. And the news is that the backlog is decreasing. We have a lot of the actions. For example, home office, we call home office in Brazil, but it's working for home. Our examiners are working for home now. And we hired new examiners, and we have a program very interesting to combat the patent backlog. So the number of patent applications for examinations is decreasing highly. We have a lot of examination acceleration measures, for example, PPH, green patents, and for startups, who is very important for this area that we are discussing, and potential infringements and elder application and a lot of other programs. Recently, the BPTO worked in patent guidelines, what was very important for us. And we have now a guideline, very new, related to inventions in the IA related fields, which is very important for us. And the news, the very, very recent news is that our Supreme Court limited the patent term in Brazil. So we are facing a very controversial period in Brazil about this subject. So for new patents granted after May 14, 2021, all patents will be limited to 20 years in all fields. And for pharmaceutical fields, the situation is that all patents granted with the higher patent term will be reviewed and the patent term will be reduced. So we are facing a lot of court actions start just now to discuss this subject, especially in the IA field. In the artificial intelligence in Brazil, where we are. So as you can see, for the recent presentations, no South American countries such as Brazil is in the AI area top list, unfortunately. BPTO is evaluating very old inventions in AI area. So we don't know how the examiners will carry out these examinations in the near future. We have several startups working in software inventions in pharmaceutical and cosmetic fields. We deal with these every day. And bioinformatics is being applied in agriculture, cosmetic, and pharmaceutical fields, especially in pharmaceutical fields in Brazil. And now we have a news, very recent news in April 2021, Brazilian government launched the new Brazilian strategy for artificial intelligence, established some Brazilian priorities. The focal areas will be health, agriculture, industry, and smart cities. There are some specific pillars to discover. I say to you to discover because this is very new for us, but the problems evolve. Study, the program involves new centers, the program involves a lot of money being applied in this area. So we are very happy with this news because we see from the world movement that this area is very important. You need to invest in this area in our country too. And the patentability is very new for us too. As I showed to you, the backlog imposed that our examiners work in very old inventions now. So where the movement is coming and the examinations will be done and backlog reduced, we will face some issues that I think that in the world are more advanced. So we can use the expertise from the, especially the United States, Europe, and other countries to apply in our examinations here too. So software can be protected by two intellectual property rights in Brazil, copyright and patents. And we have this strong view that copyright covers the source code, while the patent encompasses the algorithm. We have this difference, but these are being discussed in the academy. And BPTO recognized the possibility to patent protection of inventions implemented by computer software. And this is very controversial in the recent years because we had some periods that this was not recognized by the BPTO, but recently this view was changed, what was very important for this area. And the guidelines, the new guidelines from December 2020, established that techniques of artificial intelligence cover machine learning and deep learning and other techniques, when applied to the solution of technical problems, can be considered invention. This was an important step in our view of the AI area. The challenges of our country now, and I think that all the South America, is the new legislation that's coming, this change in this legislation, especially in the patent term, and the backlog. We need to deal with the backlog in this specific area because the movement of this area is very fast. And we have our examiners working now in very old inventions analysis. So we need to change this movement in the BPTO in order to follow the rules. And the discussion now in the academy, I can say to you, is not, we don't have practical cases, is the inventorship. Can AI be considered an inventor? There is no rule established in our local law, but the interpretation, the main interpretation is following the world interpretation that no, AI cannot be considered an inventor. But this discussion starts just now, and I think that the eyes of the Brazilian people is now in the new legislation, the new guidelines, and the backlog. This is what I can say to you. Unfortunately, our country doesn't have a lot of cases to show to you of examination, but we think that this movement, very recent movement from April, will improve our area because we have a lot of startups, small companies, and academy working in the AI area. So I think that this movement will be very strong in the next years, and I hope that we can share with you news in a near future. So thank you very much for the invite, and I'm free for questions if you have.
Thank you very much, ma'am, for an excellent presentation. So now let me introduce you all our next speaker, Dr. Mario Golub. He has graduated in 1973 as an aircraft technician and helped building the first composite glider in Latin America. The same year, he obtained his bachelor's degree. In 1974, Mr. Golab moved to Israel and graduated as an aeronautical engineering at Technician Israel Institute of Technology. In the early 1980s, he moved to the USA and worked at the NASA. In 1987, Mario received his master's degree in international management from Thunderbird and then worked as a director for Latin America for Seagate Technology and later as a vice president at Record.com. In 1997, after 10 years in various upper management positions, Mario returned to the educational clusters to obtain his Doctor of Jurisprudence degree and simultaneously a master's in intellectual property. After gaining experience at a top US law firm, Mario founded Golab Intellectual Property to offer his combined 40 years experience in engineering, international business, management, and law. He is frequently called to lecture by World Intellectual Property Organization before various universities and government and also by many other organizations. He is registered patent attorney before USPTO and is admitted to litigate at the highest courts of Florida and the USA. He is a member of Florida Bar and various IP associations. So I'll now request him to present his thoughts with us. Over to you, sir.
Working, so let me upload. First and foremost, I wanted to thank markpatner.org for organizing this very important and very timely seminar, and in particular Dr. Acharya for the invitation. It's wonderful to be with amongst colleagues and to share this very, very important topic. Let me upload my presentation here. Okay. I will be looking at this situation, at this presentation from the different perspective. First, I want to understand, I want to share with you where's the philosophy behind intellectual property in general and the specifics of artificial intelligence. This is something that as we debate existing things, we forget where we came from. Let me see. Okay. For some reason, let's see. I apologize. I practiced this yesterday, and for some reason, it's not happening. So let's see if this is happening now. Okay. Can you see the presentation that I'm sharing? You can see the presentation. Okay, so thank you. Okay. From the fruits of the creative mind, we have tools to protect creative ideas through copyright, practical ideas that are new and not obvious through patents, commercial identity through trademarks, and also the most original of all, and you can see the fourth fruit there, is trade secrets. That's what you don't see, it's a secret. Basically, we started initially the philosophy, we were a communal type of sharing of knowledge. As we developed agriculture until pretty much 500 years ago, we shared knowledge amongst ourselves, and we took the knowledge of others and incorporated it for our own use without paying much attention as to whom it belonged. The first written expression that ideas belong to somebody else were expressed in the question whether something that's the product of the mind could be actual property. In the 10th century, that's what I found, that the canon of Jewish law called the Talmud said that the theft of ideas was worse than the theft of money. That means it gave, you're required to give attribution to somebody else's thoughts. And that's the first symbol of that. But it was not until until the invention of the printing press that a major revolution took place. Now, why the printing press was such a big revolution? Remember that before the printing press, the books, the authors only require a scribe to put it together and draft it. And it may take 6 months to a year to produce a single book, to what today would be costing tens of thousands of dollars. And Gutenberg's invention pretty much took away with that, and he could actually take a book by somebody else without any attribution and sell it for a smaller price and made it in large quantities. So the beginning, the question was not who owned that book, because it was clear that whoever had the capital to buy it was the owner. The question is, was it important to have an author? In a few years later, just 24 years later, the Venetian Republic saw that as a society, it would behoove them to grant some special rights to inventors. In particular, those who had the crystal, the famous Murano crystal. But also because at that time, the Venetian Republic was one of the few places in the Western world that was in contact with the Orient. And they were bringing a lot of inventions from the Orient, and they were registering there in the Venetian Republic. In the pendulum swung the other way, and the printing press industry grew up tremendously. And in 1662 in England, they decided that the author was not important, that the society would benefit by having those with capital to print books, printing as much as they wanted. This statute only lasted for 2 years, and the pendulum swung again in 1710 with the Statute of Anne, which actually gave back to the authors the right that was discussed back in the 10th century in the Talmud. Finally, in 1787, the Constitution of the United States clearly specified that this was a society right, and it was actually owned initially by authors and inventors. But that societal right was limited in time. And that's the reason we have time limits in copyright and trademark and in patents. So why does it matter to whom it belongs? It's very simple. If there's 3 possible owners of this, it could be society. So we can have incentives to create intellectual property. Could be the owners, or could be the capital who invests on the development. Now, if you have capital, and that you throw that resources, whether are physical or human resources, it doesn't matter how much capital you throw at that, nothing will grow. However, if you have human capital, the capital could assist that in developing, and so society as a whole will advance. Intellectual property is relevant because it could be exploited for profit. You can have a nice painting with a patent title, ownership or authorship of copyright, but the true value of that both for society that enjoys the creation and for the owners is because it could be exploited for profit. The capital by itself does not create intellectual property, and that's what I was mentioning before. Okay, so the society gains when there's an incentive given to the author, or it could be to assignee, to create more and more IP. And that's the reason today we live in this marvelous world with incredible advancements in medicine, in pretty much in all areas of endeavor of the human mind. Now, the question that begs right now is, what is intelligence? Well, if we look at human intelligence, it's very simple. It's a person with the ability to acquire and apply knowledge. But if it's so simple, the word person, you can say, well, what about if it's a dog? Can a dog have the ability to acquire and apply knowledge? And for most of us who have dogs, we know that is possible too. So is that sufficient definition? Well, then we'll add something else? Well, the capacity for logic, understanding, self-awareness, learning, emotional reasoning, planning, creativity, all this type of abilities that we today associate with problem solving. But is that all? Well, we have also the ability for empathy. That means help, be concerned, love, care, and have principles and morals. But also the capacity to deceive, cajole, lie, emote, kanchi, and all the bad things. Now, for those who had the fortune to have watched Stanley Kubrick's masterpiece, 2001 Space Odyssey, you may remember that the movie is about a computer called Hall and an astronaut that goes to space, and how the computer kills the other passengers and tries to kill the last one, and how it is the ability of the human to cajole the computer into getting in, and who can survive longest, knowing that the computer will survive an eternity so long as it has power. So this was one of the things, but this was a fantasy. Now, you may remember that just last year, Boeing had a problem with one of his airplanes, the 737-800 MAX, that the computer system, pretty much artificial intelligence, that was supposedly designed to avoid patterns of flight for the airplane, actually kill the people in two airplanes. Okay, that was the problem of artificial intelligence. Well, the computer itself didn't have malice, but that's what happened. On the other hand, there was another flight from Egypt Air that took off from New York, and a pilot who wanted to actually commit suicide, he just dumped the plane into the ocean. So as you can see, the intelligence could be used for good or for bad. The question is who programs. Now, all this are human characteristics that machines cannot replicate today, but someday they will. Now let's go to the other area. What's artificial intelligence? And this is just a system that performs tasks required from human intelligence. And we can see that, for example, today self-driving cars require visual perception to see who's in front. But at the same time, a car, doesn't matter how sophisticated it is, if it needs to make a decision, for example, car is driving and is driving at high speed, and one of the passengers doesn't have the seatbelt plugged in. So the computer knows that there's a passenger that doesn't have the seatbelt plugged in. In front, there's three people. On the right, an elderly person. On the center, a pregnant woman. On the left, a young child. And the car has to brake very quickly, and it has to make a decision. That is a moral decision. Who are you going to kill? The passenger, the pregnant woman, the elderly man, or the young child? And those are the type of decisions that eventually artificial intelligence will have to deal with, because humans will have to deal with that as well. Any system that perceives an environment that takes its action to maximize its chances of achieving its goal. Now, these are logic goals, okay, that could be programmed in artificial intelligence. Now, creativity is not a random act. Creativity requires the human mind, or something that could be programmed to create something specifically. But if you use a computer, the computer becomes just a tool to create. Like we use a brush, or you use a piano to create music. In this case, if you use a computer processor to do some creation. However, in the one case, you use intelligence. In the second, you use instructions. Are they the same? The instructions will have to be very precise in order to have some creativity. But the results, in the one case, you have a creative work. In the other, I argue, you have a product. You don't have anything creative. Giving the same input, the machine produces always the same output. And that is a product. So it doesn't matter if it's a numerical control machine, or you test it, or how much you educate, a machine produces a product. Now, Where are we standing right now? Because the world has changed so dramatically since the introduction of computers in the 50s. Pretty much our world was a binary, was ones and zeros, and computers incremented their power as we could increment the capacity of processors to process binary instructions. Now we're entering a completely different world where computers are producing using quantum technology. Now, briefly, what is quantum technology? It's the probability that something is close to 1 or to 0. So you have two parameters: the parameter or the position of the electron and the probability that is closer to one or another extreme. And that it's a quantum leap. I'm sorry using the same word, but it's a tremendous leap of processing compared to binary computers. Now, why is this important? Because until pretty much 100 years ago, data was manageable. I mean, you could have a large amount of people making calculations like the Russians did to get to space, to Mars, and you can do it without computers. Today, it's pretty much impossible. Even right now, we are in the middle of the COVID-19 pandemic. Pretty much all this research requires managing tremendous amount of data for so many countries to be able to get to some conclusion. And that is done through computers. Is that an invention? That was the question. So the question right now is, who owns the creation? According to law, we discussed previously, the invention is pretty much owned by the author. The question is, who's the author? Is the machine? Is the programmer or the implementer? Is the architect the author? Or is the employer assignee? Well, in the US, Dr. Hall explained, it's very simple. The author, or the inventor, is the creator. But an employer assignee could be the owner of that creation. A machine cannot be an owner, and a programmer or implementer, it doesn't have the quality of the invention, so it cannot be an owner either. The question sometimes, computers can do marvelous things, but they can do terrible things. Who is responsible? Who's liable? Because can you sue a machine? If you grant ownership to a machine, can you sue a machine? Can a machine be responsible for the actions? I beg to say no. Who owns the machine? Perhaps. Could the author be responsible? Well, the author may have given instructions to the machine, and the machine may have created something that is way beyond the instructions as a combination of many factors that were input into that machine. So it could be that the results of the machine were not what the author anticipated. So at that point, who is responsible? Is the machine responsible, or is the author responsible? Or is the owner responsible? And that's something that will have to be determined in law. This is an interesting concept. I was talking to my wife, she's a neuroscientist, and she says that a person with high intelligence, with poor judgment, pathological egocentricity, incapacity for love, lack of remorse, lack of any human trait is a psychopath. That's the type of person. I realized that the artificial intelligence machine has exactly the same characteristics because it's only based on logic. It has no empathy. Now, what do we have today as available protection for artificial intelligence? Well, basically industrial and trade secrets. If you have an algorithm, like a Lempel-Ziv algorithm, today you protect it to trade secret and you license that. That's a compression algorithm for video and other things. Okay, so we can keep doing that, except that trade secrets could be reverse engineered, and that's a problem. Now, should we give copyright to the author or architect? And the question to that is the product of the instructions or the conceptual idea only implemented by the artificial intelligence machine, or is the result not contemplated by the author or architect? Okay, so can we get copyright? just only to the ideas of the author architect. If not, we cannot give copyright to the machine. Finally, we can give a patent, but the question again, who invented? Was the inventor availed himself or herself to a computer to develop a new product and invent a new thing? Or was the machine having a result that were not anticipated previously by the inventor? What all suggests is, and this is a proposal, that we will have to develop some sui generis protection for for artificial intelligence. It has not been contemplated, but we have to figure out whether, who's responsible, who's liable, who's the inventor, obviously not a machine, but which party in the process will do that. Because artificial intelligence, as the numbers were shown before by my colleagues, they are increasing tremendously. It is applied in pretty much everything, so ubiquitous. The car has it, the refrigerator has it, appliances in general. You get to a voicemail and has artificial intelligence to recognize your voice. There's so many areas where artificial intelligence works, and it will be embedded more and more and more into every product that we use, that those countries who will have the right legislation will encourage the creation of artificial intelligence. So it is very important to understand that perhaps what we have is not suitable, and we will need to have some unique, some sui generis intellectual property. If the results of an artificial intelligence machine are not a product, that means they are unique, then we have to have some protection. If they're repetitive, then you have a product. It's like having a numerical control machine. You put the material there, comes out the same way all the time, okay? But when you program something and there's some randomness or there's some acquired information that can make a machine take a different decision and come out with a result that is unique and is not is unforeseen, then you're talking that the machine has done something. And that is the type of thing that we need. So in this case, the author would be the owner of what I believe would be the owner of the artificial intelligence machine, would be the owner of the intellectual property and the responsible for everything. So in conclusion, the area of artificial intelligence and how to protect it is very, 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 very important. As countries rush for control to these areas, we have to have legislation developed that contemplate this as a unique thing, like we did for plants, like we did in this for VLSI design, by chip design, masks, and for different areas that require specific legislation. And we will require the specific legislation for intellectual property. Thank you very much for your time and for letting me share with you my thoughts. Okay.
Thank you so much, sir, for sharing your knowledge with us. The one question is for Mr. Kwan. Can you, sir, brief the benefits of artificial intelligence in the business?
Is it my question?
Yes, sir.
Can you please repeat again?
Can you brief out the benefits of artificial intelligence in the business?
Benefit for the artificial intelligence?
In business?
I'm not sure what is about the benefit from the artificial intelligence. Could you please a little bit more specify the question?
Maybe he wants to ask, how does artificial intelligence help business?
I think the Korea is very active in software, internet technology, internet communication technologies. The artificial is widely used in every aspect of technology field, from academic education to the companies and manufacturing and government. So I think the AI technologies apply all kinds of the general life and then laboratory and education in almost every kind of field, from the SNS. And when we using CCTV, the AI technology apply the CCTV, and we are the ordering the food in-house from application. They recommend the food we might like from our previous ordering. So every kind of things are connected to AI technology. So it's very active, I think, in Korea.
The next question. Thank you, sir. The next question is for Mr. David Ho. Can you elaborate the scope of artificial intelligence with the intellectual property rights? Sir, kindly unmute.
Could you repeat the question again, please?
What is the scope of artificial intelligence related to intellectual property rights?
I'm not sure if I understand the question fully. I think the rights has to be written in like a patent application, has to be boiled down to what we say as the proper categories. Okay, that is important first. So artificial intelligence is the invisible, very smart machine, but it has to be eligible. So if the artificial intelligence bring forth an advancement in technology, whether it's going to be this vision or language or anything, business, biopharmaceutical, medical, but that has to be what we are saying, is it a process? Is it part of the machine? Is it part of a composition of matter? Artificial intelligence can expedite the drug discovery process and come up with many, many very good pharmaceutical drugs, like in Mr. Kwan's presentation, that it is should have been a long years, 10 to 20 years, has become 3-5 years, 1 to 2 years. Those are important things. But no matter what, the invention impacted by the artificial intelligence has to be encapsulated. Is it a process? Is it a machine? Is it a manufacturer or a composition of matter? So we have to go through the same road where, yes, artificial intelligence makes the advancement quickly, much better, but it has to come down to those 4 eligible subject matter first and take it from there. Of course, one aspect in the recent years, there's a lot of headache, the 101 rejection, human activity. I have dealt with, in my personal case, invention related to artificial intelligence. Way ahead, it was application was actually in the process before the 101 rejection has become crucial. Human activities. So the good thing is, if there's a way to tie this one element of the claim back to the advancement of technology, or to show that it is significantly more than, although it is a human activity, yes, trading stocks, predicting where to shop, that if it is tied with a machine, tied with something, then it is a patentable subject matter. So it is still This is how I see it. The same 4 basic subject matter categories, and without an impact related to the judicial exception. If it is an exception, let's make sure that it overcomes that. So what it means is the professional, the patent professional, must work hand in hand with the inventor. Inventors think smarter than the attorneys, okay? I can guarantee you. But it's one aspect. But the professional has to be there to assist the inventor to be even smarter, to overcome all this potential rejection while the application is being drafted. So this is how we do it in our firm, our colleagues. We always think of how do we overcome a 101 subject matter? How do we overcome the 102? And of course, the 102 is a novelty. 103 is obviousness. So we have to think ahead of time, ahead of the game. Otherwise, once you filed it, too late. So it's not just filing, taking a Word document, filed it tomorrow, and we don't do that. We don't recommend that. So especially anything that enablement, requirement enablement. How do we show to the examiner that it is enabled and described properly? Those are very important issues. So artificial intelligence can be protected, has a right when we channel this invention properly to the 4 subject matter categories and avoid any judicial exception problems. That's anybody's comment, welcome.
Dr. Mario would like to add something?
Yes, well, actually, build on what Dr. Paul said very, very clearly. The area of patents is limited by the Constitution of the United States. We need to give the right to the inventor. So the question would be, who's the inventor? That would be the problem with artificial intelligence. So the Constitution only deals with 2 areas. That's copyright and patents. It doesn't discuss trademarks, and perhaps it will not discuss artificial intelligence. So I personally believe that we have to create new type of law, sui generis law, federal law, that will actually address this type of things. Because artificial intelligence is not only here to stay, it's just in the infancy. It will grow tremendously, and we need to have a legal framework, preferably an international one, but at least in the US, we have to have a legal framework where to develop. At this point, the only 2 areas that can be developed is if the inventor is recognized, then we can go through patents. And if there's an authorship, just we do it through copyright, and primarily to industrial secret, meaning protect this through contracts, license what is required, and try to make it non-reversible. But basically, without those things, the best solution would be to deal from a completely outside view, putting like we deal with trademarks in the US right now, which is we have federal law, we have state law. So we can create some type of federal law for artificial intelligence that will help us protect. Or again, if the inventor actually conceived the results, then the machine only implements the work of the inventor. And it's just a helper, it's a tool, nothing else.
Thank you very much, sir. So now moving forward, I request Mr. Padmin Bhuj to appraise this gathering with his vote of thanks. I am much delighted to introduce you Mr. Padmin Bhuj, who is a national level IPR domain expert, presently a senior visiting faculty with Entrepreneurship Development Institute of India. He is also project and management advisor. He holds about 30 years of combined experience of intellectual property right, corporate industry, project management, entrepreneurship development, and academics. Mr. Bhuj, as the managing director of GTCO, established patent cell at GTCO. He received the GTO Pedagogical Award for contribution in the IPR in the year 2013. Recently, in the year 2019, 2018, he was conferred with the prestigious IP Samaritan of the Year 2018 award by IPPO. He is also an invited speaker at national and international conferences and seminars on IPR. On official work and assignment, he has visited widely across the globe. He has completed B.Pharm, MBA, CMC, PG Diploma in Patent Law from Nalsar University, Hyderabad. So now I request him to deliver a vote of thanks. Over to you, sir.
Thank you so much, Jalsri. And first, I am proposing vote of thanks to Dr. Rajesh Bhai for inviting me to say vote of thanks. Okay. Okay, but no, it was actually, I'm sure all of us, including myself, are overwhelmed by the treasure of knowledge on this very, very important topic. A topic of IPR and artificial intelligence. Actually, 20 days back, we also had a webinar by Dr. Rajesh Acharya only, and I was one of the speakers. This is a topic which we need to go on discussing at the international level. We need to go on discussing. If we are all the learned speakers, whatever they have said today, we must realize, okay, while there are certain common aspects, there are several aspects which everybody was able to brought out. And this is not the end. This is going to continue. Okay. And this is something which we need to debate more and more and more. Because as everybody said, what is the difference between inventor and the author and the owner? The ownership issue is the debated. And why we want to be owner? There is a reason. The basic fundamental of intellectual property right itself is ownership, if somebody wants to have it. Okay. So that is why this is a topic which requires much more discussion, and I'm sure the outcomes will be always be positive. Mr. Young started with what say beyond the space, and he focused on the data management, the input and output data. And what was important was that he mentioned about the use of artificial intelligence in the field of pharmaceutical, particularly repurposing of the drugs. As we all know, in this pandemic of the COVID, the repurposing of the drug has emerged as one of the major development. Whether you call it a remdesivir or favipiravir or all such kind of drugs are basically repurposed drugs. In fact, I would like to add that artificial intelligence also has played a major role in development of the vaccine as also distribution management of the vaccines all over the world, including our own country, which is a largely populated country. So that was the proposal. And Mr. David Ho talk about the current issues, what is the position, current issues and the future prospects. Okay. And what was very important when he talk about the future prospects, excellent statistics of the countries, companies and universities. What is happening in the world of artificial intelligence? Now that is the future. Okay. That is the future we have to look forward to. Because ownership or no ownership, the invention, research, new things has to continue. When somebody asks about how does AI help the business in every manner, as was rightly answered, every manner. We want to do the business in a better manner. We want to business to be more meaningful, more productive, more efficient, more effective. Artificial intelligence is something, as is pointed out, is supposed to do something better than me or the person who makes the computer. So that was the very statistics was excellent. It gave an idea about what is happening and what is going to happen in the future. Madam Katia talked about the Brazil. She said that in April 2021, Brazil has come out with the new artificial intelligence related policy. We are so happy because Brazil, we look forward to doing something new. Okay. And she also mentioned about the existing IP regime in the Brazil. What was interesting to me was relating the age group with the patenting part, like senior citizens. Okay, now this was something, at least for me, it was something new. And we know Brazil, as far as India is concerned, that Brazil is doing excellent job in the field of healthcare, agriculture and pharmaceuticals. We are doing a lot of business with Brazil in terms of pharmaceuticals. And artificial intelligence has a great role to play in the field like healthcare, pharma, and agriculture. These are the fields which requires much more focus to do good. And of course, Mr. Mario gave an excellent presentation. I wanted him to speak in 7 languages. I believe he knows 7 languages or maybe more languages. While he said thank you, he also said Abhar. So Abhar, Mr. Mario. And I'm sure that next time whenever we meet, courtesy Dr. Rajesh Bhai, you will give your presentation in the Gujarati language. I'm pretty sure about that. But Mr. Mario brought out the key issue, the authorship and ownership. That is the fundamental, what we discuss in here, authorship, ownership. Okay. And when he gave a quote of a lady neuroscientist, I was really amused, and also it was something which made me start thinking. Who is a psychopath? I don't want to go into that psychopath business, but as a whole, over the learned speaker, there is one common thing which has come out. Is really a machine can be given ownership of intellectual property right or intellectual property, a machine, because we are calling that a machine. I would really pity that artificial intelligence, whether he is a he or she. I don't want to know the gender of AI. A poor fellow or poor lady, nobody is with artificial intelligence. Everybody says, no, 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 no. You are not natural person. What is wrong of not being a natural person? I have created or somebody has created a machine which is doing better job. Yeah, it is not, it doesn't have emotion, as both of us said. It doesn't have emotion. It doesn't have friendship. But it has come out with an invention which is patentable. Then why not a AI machine can be given patent? Yes, there are issues for that. If there is a case of infringement, who will going to file the case of litigation? So it's a complicated thing, but a lot of knowledge has been distributed. And I must thank each of the speaker, Mr. Young, Mr. David Ho, Madam Katya, and of course, our friend, Mr. Mario. All of you, thank you so much. Thank you so much on my behalf and on the behalf of the organizers. Okay. Thank you, of course, Dr. Rajesh Bhai, for his initial remark, which is always fine. Whenever Dr. Rajesh Bhai gives the initial remarks or talk, it sets the tone. Today, the same thing happened. And thank you also for making this happen. This is not a small thing. International speakers joining on one platform across the time zone and talking about a very crucial topic in the field of intellectual property right. We are all privileged and honored to be part of this kind of thing. So thank you, Dr. Rajesh Bhai. Thank you, Omkar, and the team of Mark Patton and the HK Acharya Company. The entire team, which is doing a fantastic job. Many of us know that every February, in the month of February, Dr. Rajesh Bhai, HK Acharya Company, Mark Patton used to organize an international seminar, which is a physical seminar. We have met there. It is going to continue. Okay. But he has continued it in a manner, some manner or other, through the webinar forum, through the virtual forum. So hats off to you, Rajesh Bhai, Omkar, and the entire team of the organization. And of course, thank you all the organizations who are well-wisher to all of us. I am not giving the name individually. All the organizations who are in the field of knowledge. We are in the knowledge economy, and all the organizations which have supported us are the knowledge organizations. To thank you all of them. And of course, thank you all the participants. Without participant, it would look like a sports event where there is nobody in the stadium and the sports is being played, which is a reality. We can't help it. But the participants are there, both who have joined this Zoom link, as well as there are so many participants, let me tell you, who are on the Facebook Live platform. There are many more there. So all the participants, thank you for joining us and asking the right kind of questions, and keep joining our endeavor, which is going to continue all these things. And thank you, of course, Jalsri, for fine anchoring and comparing. Now you can thank me also, by the way. Okay, because I have to stop now. And thank you all. And depending upon the time zone you are in, have a nice day and a good night, all of us. Thank you all from my side. Thank you all.
I would like to add some seeds for thinking tomorrow that what is artificial intelligence? It is just logic we are putting into the machines. We are putting day by day more and more logic. So it's becoming faster and faster. It becomes more and more accurate day by day. As it is said by Mr. Go, that it cannot have emotions or friendship. But maybe tomorrow some scientist will put a logic of emotions and also the friendship. Then machines will have emotion and also friendship. It is going to happen because what is happening at a fast rate. Machines are more accurate, faster, better in many, many ways. Then only one thing we'll have to keep in mind, that we'll have to control this artificial intelligence. Otherwise, tomorrow, this artificial intelligence will control us. Thank you.
Thank you so much, sir. And thank you so much, Mr. Padmin Boj, for delivering both
Thank
of
you.
nights.
Yeah.
So, in closing, I wish to express my gratitude to all the delegates and observers for their full cooperation and active participation. I would like to thank all the wonderful people who spoke and enlightened us with their amazing knowledge and ideas. It's been an honor to and among such an accomplished individuals. Thank you all for your patience. We are privileged to have in attendees such an distinguished experts as well as observers. Having such resourceful and knowledgeable delegates which have helped us to gain insights on strengthening mechanism as a means of promoting IPR. We convey our sincere appreciation to our distinguished guests who have been actively participating from all way across the globe to make this webinar a huge success. I wish you all a blessed day and a good day. And Mr. Kwan, have a good night. With this, we sum up our session. Thank you, ladies and gentlemen, and wish everyone to stay home and stay safe.